Hello, my name is Brian Hope, and I'll be presenting my PowerPoint on the legal conflicts surrounding unmanned aircraft systems, UAS, or otherwise known as drones, and their operations in our aviation system. Since the invention of flight by the Wright brothers, inventors have pushed the envelopes to reach new frontiers. From propeller aircraft to jet aircraft to spaceflight putting a man on the moon, and now unmanned aircraft systems, or drones, have also created new frontiers for us. With the recent drone revolution, many questions have arose. What are the rules and who makes them? How do drones mesh with the existing FAA airspace, especially with manned aircraft? Questions about privacy and security. What past legal cases offer guidance in present and future laws regarding drones? Legally, drones are allowed to fly in the same airspace as manned-operated aircraft. As drones become more prevalent for commercial, recreational, and governmental purposes, ensuring their safe and efficient operation alongside these manned aircraft is a key priority. The United States National Airspace System is controlled by the FAA. The FAA provides ATC to 45,000 flights daily, also including 2 million passengers a day, and the airspace is about 29 million square miles in size. As drones become more and more prevalent in the world today, questions like who gets to make the laws that drone operators have to follow? Is it federal laws? Is it state? Is it local? Maybe it's city rules? There was a lawsuit in 2017 where a resident of Newton, Massachusetts sued the city regarding their very rules on drones. The local Newton laws did not permit drone use under 400 feet above private and city property. Still, the FAA regulations require drones to operate below this very altitude. In this case, the federal court affirmed that the FAA holds a greater say in drone regulations than local governments across the United States. This decision established a ruling that the federal government holds a greater jurisdiction over the drone industry. In this ruling, the judge stated that Newton's choice to restrict drone use below 400 feet thus works to eliminate any drone use in the confines of the city. This thwarts not only the FAA's objective, but also those of Congress for the FAA to integrate drones into the national airspace system. Along with the rules and regulations about who controls the airspace for drones, privacy laws also need to be addressed. Most of the concerns about privacy are centralized around the Fourth Amendment right. And this is the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall be issued upon probable cause supported by oath or affirmation, and the particularly describing the place to be searched and the persons or things to be seized. So this Fourth Amendment right is pretty much centralized around the unreasonable searches and seizures by the government. There's a case where in Long Lake Township versus Todd Maxson, Todd Maxson had a piece of property that the city thought he had too many cars on, so they flew a drone over his property, took a bunch of pictures, and then used it in court to get him to clean up his property. And this begs the question of, is this allowed? Should the city be able to fly a drone over the property and take pictures of this person's property? So do you need a warrant or don't you need a warrant? We're going to talk about some other cases, and so as we move forward, we'll address this case later on in this presentation. So what about surveillance by police and law enforcement? Police departments love to use drones because they can use it for surveillance, search and rescue, scouting raids. They can even make announcements. The advantages of using these drones saves time and money, increases the efficiency of the police department, and also protects officers as they're able to use drones to be in places that might be dangerous for police officers to be on the ground. Over 1,400 police departments are now using drones on their police force. The Fourth Amendment rights versus police surveillance. So, is this an invasion of privacy? Do you need warrants? There's several cases that have been brought forth to courts to decide this very question. Most of them are based on marijuana growers, and probably because marijuana was not legal back then, we've got some cases where surveillance comes to the forefront. One of the cases is California versus Ciarollo in 1986. In this case, an airplane flew over at 1,000 feet to survey a marijuana operation in this backyard in California. The question was, does the airplane surveillance at 1,000 feet, is that something that needs a warrant? The courts in this case ruled that the Fourth Amendment was not violated because they thought that this was not a protected airspace. And they determined that it was not a protected airspace because anyone in any airplane flying over that property could see his yard with the naked eye. So it wasn't just a police operation. Other people could see it. And the quote from the legal argument was, the Fourth Amendment does not require law enforcement officers to shield their eyes when passing by a home on public thoroughfares. Another case that has to do with the Fourth Amendment rights and police surveillance is Florida versus Riley. In this instance, the police got a tip from somebody that somebody was growing marijuana in their backyard, and the police in a helicopter flew at 400 feet over the greenhouse, where the greenhouse had some panels open, and so they could look in the greenhouse and saw that they were indeed growing marijuana. Does surveillance from helicopters at 400 feet constitute the need for a search warrant? Now, in this case, originally the Florida case had determined that this was required to have a warrant, but then it went to the federal level, and the courts there said, well, helicopters can fly under 500 feet per FAA regulations, but in this case, they also clarified what aerial surveillance search means. Number one, it asks, are any laws being violated? Number two, if flights were substantially rare in the area. And three, if surveillance interfered with normal property use by causing noise, winds, or threat of injury. So in this case, they determined that you didn't need a warrant to use that footage in the legal case. The third and last one of the Fourth Amendment rights versus police surveillance is Kylo versus the United States in 1991. In this case, they had a tip that somebody was growing marijuana in their house. And what the police did was they parked a car out on the public street and used thermal camera imaging to see that there were hot spots in the house that showed that, boy, indeed, they're growing some marijuana there. So the question in this was, can you use advanced technology for surveillance? And the U.S. Supreme Court in this one said it was a violation of the Fourth Amendment because the police department had used technology that was not readily available to the general public. And these intimate details of the home would not have been knowable without actual intrusion or somebody going in the house. So in this case, they determined that you did need a warrant. So the outcome of these three legal cases, with the aircraft in the first case at 1,000 feet for surveillance, they didn't need a warrant. And the second case, helicopter flying at 400 feet, they didn't need a warrant. But the advanced technology for searching in the third case, a warrant was needed. So with these three legal outcomes, how do these apply to drones? Because drones can fly at any altitude. They could be in the National Airspace System above 400 feet, and they can also be below the National Airspace System. They are also readily available to the general public, so they're easy to get. And are they considered advanced technology? With them being readily available, it doesn't seem like advanced technology would be a yes in that question, but they can be outfitted with other cameras and things that might take it to another level. Unfortunately, the Supreme Court has yet to rule on any drone litigation or definitions. So each case from here on has been something from the past and trying to use maybe regular aircraft jurisdictions, trying to parlay that over to drone operations. And so since the Supreme Court has yet to rule on any cases involving drones, one way to avoid litigation is to have rules and regulations to help mitigate understandings. The FAA in 2023 came up with a fact sheet that helps to clarify the do's and don'ts of flying drones and who has authority over the laws. Since the FAA is in charge of aviation safety and has full authority over the airspace, the government came up with this list of rules. First of all, Congress has given FAA full authority over aviation safety. Federal regulations preempt state and local laws. So in this fact sheet, it says if there's a federal law and a state government comes up with a law that looks more restrictive, the federal law will be the one that they follow. And then they also said state and local laws will be preempted if it conflicts with the FAA. And also state and local laws affecting commercial UAS will be more likely to be preempted. So they're trying to just lay down a foundation that if people are setting up drone rules for their city or their county, that they were going, okay, let's follow what the fact sheet says, and then we can work from there. The FAA, hopefully this will allow laws that will may or may not be allowed under these fact sheets. The next thing that the FAA has come up with that will help with drones is a remote identification of UAS. The FAA has looked for ways to enhance safety and security, and they've come up with a way to identify and track drones while they're flying. It's kind of like a digital license plate. So coming up soon, drones flying inside the United States airspace will broadcast a remote identification location and information. This picture here shows just everything that's going on in the airspace and how kind of drones fit into that operation. But by establishing this framework for tracking and identifying drones in real time, remote ID not only enhances safety measures, but also facilitates the development of more advanced and complex drone operations in the future. There has been a case with regards to the remote identification that the government is wanting to enact. Brennan versus Dixon in 2022, Brennan argued that the remote ID rule was a constant warrantless governmental surveillance in violation of the Fourth Amendment. And the ruling that came down from this was the judge said that the drones are flown in public and requiring a drone to show its location and that of its operator, while the drone is aloft in open air, violates no reasonable expectation of privacy. Kind of like driving a car. You have a license plate and you're driving around on public streets, and they're saying that that's not a private location, and so the Fourth Amendment doesn't apply to that situation. So back to the Long Lake and Todd Maxson, the man with all the cars. Did they determine that this was a situation where they needed a warrant? They concluded that much like the infrared imaging device discussed in the Kylo low-altitude unmanned specified targeted drone surveillance of a private individual's property is qualitatively different from the kind of human-operated aircraft overflights permitted by the Riley and the Cirillo cases. So they determined that there is a reasonable expectation of privacy, so such surveillance implications the Fourth Amendment and is illegal without a warrant or traditional expectation to the warrant requirement. So that was a case where a drone over property operated by the city was determined to need a warrant. Proverbs 28:5. Evil men do not understand justice, but those who seek the Lord understand it all. Justice safeguards the fundamental rights and freedoms of all individuals. Justice holds individuals and institutions accountable for their actions. Justice serves as the bedrock of our legal system. And by upholding the principles of justice, our legal system can fulfill its purpose of safeguarding individual liberties, resolving disputes, and advancing the common good of society. This, I believe, is what God has called us to do as citizens, especially here in the United States. And by having these good laws and regulations in place, we know where the boundaries are of what's right and what's wrong. As drone technology advances and becomes more prevalent in various industries, legal challenges related to privacy and Fourth Amendment protections will remain at the forefront of discussions. The integration of drones into commercial, recreational, and governmental operations will be influenced by FAA regulations, including the implementation of remote ID requirements to enhance our airspace safety and security. While the Supreme Court has yet to rule on specific drone-related cases, past legal precedents provide valuable guidance on the boundaries and protections that may shape future drone regulations. The interpretation of Fourth Amendment rights in the context of drone surveillance and the data collection is a complex and significant issue that warrants careful examination and judicial review to ensure a balance between innovation, safety, and privacy. By addressing these issues thoughtfully and collaboratively, the aviation industry can harness the benefits of drone technology while upholding individual rights and maintaining a safe and secure airspace for all users, drones and people. Thank you.